Alright, kiddos. I got an email this morning that said my filings were received. This is on the civil case. And I figure we'll do some coverage on this because I want to document it. People like court cases for some reason, but everything in here, just so you know, because YouTube will come in here. This is government website, Civic Tech, Florida. County Clerk of Court. So any redactions that were needed should have been done by the county clerk and the comptroller and clerk staff. So anything that would be deemed personally identifiable, I guess it's not here because they didn't bother to redact it. But yeah, so I mean, they denied my defendant's motion for rehearing. There's also an appeal in there. I'm sure they'll deny that because that's all they do is deny stuff. So I filed it on 3/11 of this year. Petition to compel trust documents and accountings. I state that I'm a beneficiary of this trust, or at least I was between 1999 and 2021. You can go look at this, and this is the way it came right off the clerk's site. It was established in 1999. I make my claim here. And where there's a controversy, there must be a remedy. It's a legal maxim. He who like makes makes a controversy, but basically is he who makes a controversy must provide a remedy. But you can't get any remedy because it's in the real court. So I say when the trust was formed, I've dug all this stuff out. I know the truth. I know what it is. These people know what it is too, but they won't. It's not an actual court. Some citing statutes. It's governing law, statutory law that's supposed to make this stuff work the way it's supposed to work. They don't care about that. So I'm talking about breach of fiduciary duty, failure to provide notice of trust amendments. She took me off. My trustee took me off on December 21st, 2021. We have evidence of that. And she didn't give me any notice. Or the trust documents is required, reflecting that. So she broke a law right there. But they never read this. They stamped it when I went in there. And you'll see on further documents, you'll see where the judge says received. The judge never looked at this. My original statement of claim, the judge is not looking at it. So I'm talking about being kept reasonably informed. Precedents and legal framework. Citing case law that covers this stuff. Talking about bookkeeping. And what relief I seek. And you'll notice that they put this down between like $5,000 and $8,000. I didn't ask for a dime. So I put, since this matter primarily concerns the straightforward issue of compelling the production of trust documents and accountings, it falls within the purview of small claims court jurisdiction. Cite and statute. Tell them that they can have all the jurisdiction they want. I'm just looking for paperwork. Just paperwork. That's it. I even go and get it notarized. Get it frickin' notarized. This dog's being annoying. Spent all this time. They don't care about that stuff. I file for indigency status. Well, there we are. Indigent, approved by the court. I'm indigent? I'm chronically homeless, so permanently fully disabled. I don't care about that stuff. But they approved me. Go and do the damn cover sheet. And I'm going to repeat. there's no personally identifiable information in here that and if it is, it's because the court. This is a government website. Anybody can look at this. This is newsworthy, and it's informative and educational. So here's my civil cover sheet. Breach of trust. Jury trial. Yep. But they're not going to let me have a jury trial. They won't even let you get that far. They're going to deny you right off the bat. Jury trial demanded the complaint. Yep. Come on. Internet's so slow out here. So we go ahead and have a summons to appear. Summons served. This is just all the technical crap of it. Return of service. And then they set the trial for 5:30 from 3:11. I was supposed to have a hearing within 50 days. And they scheduled for 81. It is by law. By law. They don't care about laws. So then, this right here, this is legal gold in the judge's eyes. It's absolute gold. Motion to dismiss. It's filed, received, and there's absolutely no legal basis in here, no legal framework, nothing based in law. So Patty says she does a motion to dismiss, never serves it on me, which violates civil trial procedures. It should have resulted in a default judgment for me, but that's the law. They're not going to worry about that. So trust fund does not exist. What exists is living revocable trust, to which I am the trustee. Trust fund. So there's a trust that's not funded. Plaintiff was intentionally removed from the document December 1st, 2021, for reasons best known to me. So she's saying that I was on the trust. It was formed in 1999. We know that for a fact. I was on it until 2021 when she took me off. Without question, I'm a beneficiary. And I was entitled to everything I was asking for the last 25 years. She says I'm ignorant to what a living revocable trust is. Her petition or remedy has no place in this type of private document. So she's talking to an attorney and just putting down whatever she can. So there's no remedy in a private document with my name on it. And to be ignorant, she claims I'm ignorant, when the trustee is supposed to keep beneficiaries reasonably informed. And she's saying I'm completely ignorant, which it admits right there that she's not doing her job. And then she goes on to talk about stalking on June 4th. Then she takes me off of in December. And then she says, continual harassment. She says I'm continually harassing her. And she says I harass her elderly sister, which is my aunt, her grandson, which is my son, and my grandson's mother, which is my ex. Well, where's the evidence? There's no evidence of this. Then she talks about anonymous phone calls. It's alluding to like hitmen. Anonymous phone calls. Where's the evidence of that? Why haven't you called the police? And she impersonated me, get copies of personal documents. Where's the evidence of that? It goes on to talk about my YouTube channel. It says, defy judge's orders. And then she attaches, you'll see there's no statute in here, no nothing. There's claims with no evidence. And then she puts screenshots of my community tab with little arrows. Little arrows. And she gave me a thumbs down here too. Look, she gave me a thumbs down. My own mother, my trustee, gave me thumbs down. But yeah, nothing based in any sort of nothing supported by any statute, any law, nothing. Just screenshots and claims without evidence. So we do a response to this motion. And I talk about the failure to serve. She didn't serve me that motion, and that's a violation of civil trial procedures. There's no certificate of service. It never happened. But the failure to serve undermines the respondent's motion, warrants its dismissal. And then I asked for summary judgment. But if you look at this was electronically filed. There's no stamp on here. And you'll see it later. You'll see it later where it's stamped as received. They didn't even look at this. Clarification of trust. Yeah, I put down that I acknowledge that it's allegedly a living irrevocable trust. We know that. But she tried to put trust fund. I don't think I ever said trust fund. And then I restate that I'm supposed to be kept reasonably informed. Well, she claims I'm ignorant. Well, I shouldn't be ignorant. Removal from the trust. Once again, they never read this. And the respondents claim that the petitioner was removed from the trust on December 21st, 2021 as noted. That's rock solid evidence right there. And an admission that I'm a beneficiary. I never got formal notice that I'm supposed to. But the trust documents and the alteration, the omission constitute a violation of Florida statute. And all these Florida statutes, they're based upon Uniform Trust Code, which I think like 30-something states follow, if not more. So she's supposed to notify me of any trust amendments. I put down understanding of trust. The respondent suggests the petitioner does not understand what a living revocable trust is. The petitioner claims and asserts that she understands the nature and implications of a revocable living trust. So again, she didn't keep me informed. And the harassment claims. And this has become a big issue. I have another video uploading right now that they're saying I'm making threats or claiming that quoting movie lines from a children's movie is threatening. So I put the respondent alleges harassment and violation of a protection order. The petitioner strongly refutes these allegations. The petitioner asserts that she has exercised her legal rights as a beneficiary to request information about the trust and its administration. Any claims of harassment are unrelated to the issue at hand and should not distract from the respondent's obligations as trustee. The petitioner asserts that her actions constitute a lawful exercise of her rights as a beneficiary and do not amount to harassment. Additionally, respondent states that she allegedly received anonymous phone calls threatening harm to her, yet has not provided a police report or incident number, which is both very concerning and alarming. We have Pasco detectives looking at my channel. They've admitted to going through my channel. They said they happen to fall upon a video. They surely can't only be focused on one. How come they're not looking at the career criminal that stole my house and 37 or 38 others? They know this stuff's going on. Disrespect to the court system. I've acted in honor. I haven't disrespected them. They've disrespected me. They've acted in dishonor. So I asked for a summary judgment. It says under the Florida summary judgment standard, the court shall grant summary judgment if movement shows that there is no genuine dispute as to any material facts, and there isn't. She didn't counter any of these. The respondent's failure to dispute any material facts and claims warning summary judgment in favor of the petitioner. So I asked that they deny the respondent's motion to dismiss due to failure to serve and proceed with the petitioner's original petition to compel trust documents to the county, grant summary judgment since she failed to serve me, compel trust documents under the statute based in grounded in Uniform Trust Code and Florida law, declare the respondent breached her fiduciary duties and issue a declaration affirming the petitioner's rights as a beneficiary of the trust, award legal fees. I haven't asked for a dime. I asked for $0. I just want this paperwork that I was supposed to have in 1999. And like I said, there's nothing redacted here, and that's on the courts. I'm going to restate through the video. that this is a government website. This is all public information. And they should have redacted a lot of this. All right, so then we get, what are we on here? Oh, there's a petition to reschedule pretrial conference, request for a jury trial, correction of clerical errors, because they spelled her name Patricia. And you'll see this isn't stamped at all. Even though it's filed, it's got the stamp from when I filed it. They didn't look at this. They didn't look at the last thing. They didn't look at my original statement of claim. They've looked at nothing. And I asked for a designation of the email address. So I'm asking to reschedule the pretrial conference. Petitioner respectfully brings to the court's attention that the initial pretrial conference has been scheduled for 81 days after the filing of the case, which is beyond the 50-day limit stipulated by Florida rule. These are court rules and procedures that the judges and the courts are supposed to follow, but they don't. 7.090B, 50 days, not 81 days. So I say that I believe this is scheduling may have been an oversight. It wasn't an oversight. They do it on purpose. They don't care. They do not care. So I asked that they do it by the rules, but they're not even going to read it. Ask for a jury trial. They won't let you get anywhere close to a jury trial. The formal written demand for a jury trial, supported by this 7.150. I did a tremendous amount of research on this. I spent a lot of time on this. I know what I'm talking about. And I support it, but if they don't read it. And I asked to correct a clerical error. The petitioner wished to bring to the court's attention a clerical error on the respondent's first name, which is misspelled as Patricia instead of Patricia. Asked them to correct the errors under Rule 7.1908. They still haven't, this has been months, and they still haven't freaking changed it. You know, to ensure accuracy of court records. As for a court reporter, petitioner, being indigent, requests the court provide a court reporter at no charge. Petitioner believes a court reporter is necessary for creating an accurate record of the proceedings, which is crucial in the event that an appeal needs to be filed. And I knew an appeal would be to be filed. And I know they'll deny it because it's not a real court. Petitioner first admits she's unable to afford. Then I ask designation of email address. The petitioner respectfully requests the court to compel the respondent, Patricia, to file designation of email address. The respondent has failed to provide an email address which necessitate the petitioner serve her by mail. This creates additional work and incurs extra expense on the petitioner who is indigent. Moreover, the petitioner wishes to bring to the court's attention that she is disabled. The additional work and stress caused by the need to serve the respondent by mail exacerbates and challenges associated with my disability. The situation not only places an undue burden on the petitioner, but also hinders her ability to effectively manage her case. Absolutely not. They're not going to freaking. They won't tell my mother to provide an email address so I don't have to schlep down to print something out, schlep down to the post office, pay for a green stamp, and mail it out to her. When it can just be done by email. They don't care about that. They're not even going to read it. I put my certificate of service on there. And then on the 22nd, we're getting close to trial. And I've already asked for accommodations that she designate an email address. So I asked for compel a remote hearing under the Americans with Disabilities Act. To say I'm representing myself, I'm filing petition remote hearing under the ADA. I'm a person with disabilities. Due to my disabilities, I am requesting reasonable accommodations in just the form of a Zoom hearing. And in the truth be told, if they had done this within the time frame that they were supposed to and bound by freaking trial procedures, I probably could have shown up. But no, they don't. They're just compounding stuff. You know, participating in court proceedings in person would cause significant stress and anxiety, which would exacerbate my existing conditions and interfere with my ability to represent myself. My certificate of service. But yeah, they didn't stamp that. They didn't look at it. They did not look at it. All we have is the timestamp where I e-file it. So then the trial comes up on the 30th. And they put me down as a motion to dismiss granted. So they grant her a motion to dismiss because they never looked at any of my stuff. Nothing. And then her crap's not even grounded in any freaking legal framework or nothing. So if they go ahead and they oh, here's the order. And you can see that's all stamped. It says, before this cause came before the court, small claims pretrial conference on the defendant's motion to dismiss plaintiff's petition with prejudice. An or tennis motion, which means an oral argument that I wasn't able to be there for because they denied my ADA accommodations. And the court, having heard testimony and argument of the defendant, plaintiff failed to appear. No, they denied me my right to due process. They denied reasonable, very reasonable accommodations. Just give me a Zoom hearing so I can be there. And it says, so a petition brought by the plaintiff seeking to compel an account, not an accounting, no, all accountings and all trust documents. All of them, not an accounting. Plaintiff's petition alleges she is entitled to an accounting, all of them, and to all trust documents. Patricia M. Teeling appeared at hearing, presented evidence that the trust at issue is a revocable living trust, and Tasha Teeling is not a beneficiary of said trust. Whatever evidence she allegedly presented was not even filed on the record. We can't even see it. That's exactly what I need to see. Where's this evidence? It should be a trust document. They say, yeah, Tasha Teeling is not a beneficiary of said trust. But I was until 2021. Therefore, defendant's motions are granted, and this matter should be dismissed. Gosh, the internet's so slow out here. So this is stamped. This is the motion to dismiss, where she just put screenshots and stuff. Screenshots. And she subscribed. My mother subscribed and gave me thumbs down. My trustee. So not one mention of statute. Nothing refuting anything I said. Not a damn thing. But it's received July 6th, March 25th, March 20th. You know, they looked at this thing over and over and over again. But this is Exhibit A. You can pause that and read that if you want. It's the community post. And then they went and they redacted. Somebody redacted something on the on that which wasn't redacted. But I'm gonna say it again. I'm gonna state again. This is a government website. This is all public information. There's no personally identifiable information that the court and the government did not take out. So then I go ahead and I get it reopened. So motion for trial and demand for reasonable accommodations. And you can see this isn't, it's not stamped, not nothing. I e-filed it 10:51 p.m. So it's a demand for rehearing. Restate, I'm disabled. I want a new pre-trial. I want a jury trial, but I want a pre-trial, and I want to appear by Zoom. So they denied my request because they didn't even look at it. I believe the court's ruling was a mistake and intentional oversight. It wasn't a mistake. It wasn't a mistake. It was on purpose. I asked them to respect my rights, supported by case law. Tennessee versus Lane. Well, they had a guy in a wheelchair. They made him try to make him climb stairs in a wheelchair. And then arrested him for failure to appear because he couldn't get to the second floor. I do a motion for, this is motion for a trial. This is something else. I submit this. Demand for reconsideration. Talk about denial of due process. Because they won't even correct her name. Patricia. I talk about the 14th Amendment. Put a lot of time into this. Talk about the Florida Constitution, being deprived of rights and property without due process. Violation of civil trial procedures. The respondent's motion to dismiss lacked any legal basis. It was not grounded in law. Talk about how it's never served on the petitioner, which is direct violation of the civil trial procedures. That the applicant was therefore deprived of the opportunity to respond to the motion, resulting in unfair proceeding. More case law. Denial of ADA accommodations. Backed up at Tennessee versus Lane. Violated Article 2 of the ADA. Denial of fair and equal access to the courts. Court dismissed the petitioner's case and granted the response motion to dismiss that was not legally grounded and not served the petitioner. Denied ADA accommodations. Totally ignored. Absolutely ignored. Due process violations. This is the court has violated my due process. Equal protection, the 14th Amendment. Guarantees me equal protection under the court of law. In the court of law. Under the law. So the trial court's actions contravene these constitutional protections. And Bodie versus Connecticut underscores the fundamental right to access the courts and due process guarantees. Misrepresentation of beneficiary status. The court accepted the respondent's claim that Tasha Teeling was not a beneficiary of the Teeling Family Trust. The respondent's assertion that the petitioner was removed from the trust in 2021 serves as evidence that the petitioner was indeed a beneficiary from the trust's inception in 1999. The court's acceptance of this unverified claim without any supporting evidence entering the court's records constitutes a violation of the applicant's due process rights. The principle established in Armstrong versus Manzo emphasizes that due process requires that a person be given an opportunity to be heard before being deprived of a significant property interest. Change of name. The applicant had legally changed her name prior to the proceedings. This change may have contributed to the misrepresentation of the applicant's beneficiary status. Because they said Tasha Teeling's not a beneficiary. No shit. The trial court failed to consider this crucial factor, and they know exactly what's going on. They know that I'm a beneficiary. But if they don't give me a Zoom hearing or a telephone hearing, preferably a Zoom hearing, you can't. I was denied all access to the courts because that could have been talked about then. And where is the evidence? We got case law, Goldberg versus Kelly. Due process is a flexible concept that calls for such procedural protections as the particular situation demands, including the trial court should have considered all relevant factors. Once again, it's all public information. And I do a notice of appeal. The notice of appeal is very similar to the demand for reconsideration. It's basically the same thing. So I'm asking for an appeal, which I should have had to ask for, because that moves you out of small claims court where the rules are supposed to be looser, and it's meant for the common man and woman. That isn't a lawyer, but they're going to make this. It's not even. They will deny the appeal. They will absolutely deny it because it's not a real court. So demand for rehearing. So they actually stamped this one. The judge actually looked at this. Demand for rehearing. Talk about them did the same thing, denying my ADA accommodations. I believe the court's ruling was mistaken, intentional oversight. It was a huge mistake, and it was an intentional mistake. They did this. They just didn't look at anything. Let's get citing Tennessee versus Lane. So then today, we get this. The judge issues an order. Because of course they're going to deny me. They deny me for everything. The other trial, it's been going on going on 2.5 years now. Put in motions to dismiss, demands to dismiss, they don't look at it. They won't even. The way it's not stamped on any of this, on any of my stuff, shows me that they didn't look at it. That he looked at my last thing. So the court finds as follows: this action, a petition brought by the plaintiff seeking to compel an accounting. No, all accountings. The defendant appeared in pretrial conference and according with the rules. The pretrial conference was set way too late. It's not even the right person. They have her name misspelled. And there's whatever evidence that they say she presented should have been entered into the court records. But it's not here. It's nowhere. So they said so the defendant asked for a motion of summary disposition after violating all these civil trial procedures, violating frickin' trust law. It's not about these laws. It's just set dressing. So this is: a plaintiff is not a beneficiary and not entitled to an accounting. Right, maybe after 2021, but between 1999 and 2021, I was entitled to all of that. Plaintiff filed a motion for rehearing and demand for reasonable accommodations. Plaintiff claims she did not appear at the pretrial conference because she was in need of accommodations. This court provides reasonable accommodations in accordance with the law, and plaintiff has failed to avail herself to such provisions after being provided notice of its availability. When was I provided notice? So the summons notice of hearing states as follows. It says, if you're a person with disability who needs any accommodation in order to participate in the hearing, you are entitled at no cost to you to the provision of certain assistance. Please contact either Pasco County. So they wanted me to call. I have called there before. Nobody gets back to you. They don't answer the phone. They won't get back to you. At least 7 days before your scheduled court appearance. I put it in writing to the judge. I have the emails from the judicial assistant that I'll publish later. My other attorneys on the other case do exactly what I did, which is the correct way to do it. To file for a motion for accommodations, not to call some number. And I did it 7 days before, but I didn't call the number. I just put it in writing to the judge, but you got to call some lackey? That's bullshit. I absolutely did what I was supposed to do. Plaintiff received the summons notice hearing on March 11th and did not seek accommodations in accordance with the above style notice. So these people, they can't follow the rules, but apparently I didn't follow them to their liking by not calling the number, I assume. Moreover, plaintiff has not asserted any new evidence for the court to consider. Well, where's the evidence? All lies with my trustee. I don't have a single copy of this paperwork. She admits I'm a freaking beneficiary. Any new evidence? But they're not going to look at it anyway. But there's a million other things I could say. But the next thing we're waiting on is this notice of appeal. I would almost put my life on it, like everything else, that they're going to deny it and they're going to uphold the decision because it's not a real court. You will not find any remedy, any controversy you have. Once these people become biased against you and prejudicial, it's done. I put a lot of work into this. Everything is 100% dead on. Everything is grounded in the truth, grounded in their stupid statutes and law. And it doesn't matter. They don't follow the law. They don't look at the law. They don't care about you. They want to promote an agenda. They know that I'm a beneficiary of this trust. They know that this woman broke the law. They know that she doesn't have a leg to stand on, but they're going to support her. They're going to support her, do whatever she wants, because they do not like me. They're out to get me. But there's a million things I can add. This is going on 34 minutes. I don't know who's stuck in here, but I know there's a few people that'll watch this whole thing because it's important. I know people are going through the same shit. But this is what you get. And they want to upset you. They want to upset you all the time. But I'm just documenting this. I know the truth. I know what the truth is. Patty can take her money, cram it up her ass. God's going to sort all this out. I don't have to worry about a thing. I did what I was supposed to do. I know what the truth is. Everybody else knows what the truth is. This court don't care about the truth. They don't care about laws. But comment below. Let me know what you think. Let me know what you're going through. Give me a thumbs up. Share me out. All that fun stuff.